Hi, I'm Neil O'Reilly with O'Reilly Law. I represent clients throughout New York and New Jersey. Today is March 16th of 2020. The date is relevant because right now we're dealing with the coronavirus and all the various disruptions it's putting in our personal lives. I've gotten a number of calls from potential clients, family, and friends asking what are the essential legal documents which I need in case something should happen to me or a family member to make sure that all the personal matters can be taken care of. Some of the people who've called me have been a little nervous. So the purpose of, I'm making 3 videos today. The first, this video deals with powers of attorney. The second video is going to deal with healthcare proxies and living wills. The third video is going to deal with your will. The whole purpose of these videos, the discussion is not state specific. We're just discussing what these documents are generally. So no matter what state you live in, you can know what a power of attorney does, what a healthcare proxy and living will do, and what your will does, why you need them, and what some of the pitfalls are. So with this information, I'm hoping that this will be one area where if you don't have these documents, you'll know why you need them, and you'll have an understanding of what they are. My goal is to get rid of some of the unknown, and when we get rid of some of that unknown, your mind can be at ease, and you can just take care of getting these documents quickly. So even if you go to an attorney, you know what questions to be asking or where the conversation is going to go so that you're not trying to process all that information, which can sometimes be overwhelming for clients. And also, since these are videos, if either you or a family member has a question, I'm breaking this down into 3 videos because this first video, I've done this a number of times. This is not my first take. This particular video is going to be a little long. It's going to be possibly around 13 minutes. You know better than me right now because you can look in the bottom left corner. You know exactly how long this is going to be. But I want to make sure that these are smaller so that you don't have to go through a whole video to find the living will section. So you know this video is about powers of attorney. You know what the next 2 videos are about. If you have questions, you can watch this multiple times. You can hopefully show this to a family member or a friend. They can watch it. And this way, you can know the information you need to know. You can learn some of the pitfalls. If you have any questions, please post them below or contact me. But that's my goal here is with this information, there's enough to worry about right now. You'll know this information and you'll know how to proceed. And this is one more thing that can just be off your plate and you don't have to think about again. So, powers of attorney. The whole reason why you want a power of attorney is you want to give someone the ability to act on your behalf to make financial decisions, administrative decisions, or governmental decisions on your behalf and to take actions in accordance with those decisions. So, financial decisions would be, if you run a business, someone who can run that business for you. If you have a lawsuit pending, they can carry on that lawsuit for you. For administrative decisions, it would be if you're dealing with insurance claims, whether it be medical claims or if there was an accident and maybe that's why you're incapacitated. They could deal with the insurance company for you. For governmental decisions, if they needed to deal with Medicaid or Medicare or Social Security on your behalf, this is how they would be empowered. Now, if you don't have a power of attorney, they have to go to court and they have to get the ability to act on your behalf. Because normally, these various companies or these agencies should just say, I get that it's your brother, your mother, your father, but I can't deal with you. I have to deal with them. So you have to go to court and you have to become a guardian. If there's no power of attorney, you have to get what we call guardianship. The difference between a power of attorney and guardianship is power of attorney operates immediately and it's much cheaper. A guardianship, you have to get a doctor or a psychiatrist to say that the person is incapacitated. They have to examine you. They have to file a report. Then a complaint has to be generated. That has to be filed with the court by your attorney. Generally, there is a time period so that everyone who needs notice of this action can get the appropriate notice. There may be someone, the reason why we have to give people notice, there may be someone who thinks you don't need a guardian. There may be someone who thinks they should be the guardian instead. Also in that time period, the court will appoint what's called a guardian ad litem. And that person will act on behalf of the court. They're the judge's eyes and ears, and they will visit with you, and they'll visit with everyone else involved in the matter to see, do you really need a guardian, and Is the person who's made the application for the guardianship the best person to be your guardian? So there's a significant amount of time there, and there's a good amount of expense. There's expense for the person bringing the guardianship. They have an attorney. You may decide you want to hire your own attorney. You may say, I don't need a guardian right now. You may hire an attorney. There's the guardian ad litem. They get paid by you. So they don't get paid by the court. So, well, generally, in New York or New Jersey, that's my experience. Other states may do that differently, but in New York or New Jersey, that's what happens. So with that amount of time, the delay that would cause in either dealing with your personal matters and the expense could be significant. If we have a power of attorney, it can be done quickly and it can be done relatively cheaply. The next issue to deal with is, now if we have a power of attorney, how does it proceed? Well, you nominate an attorney in fact or attorneys in fact to act on your behalf. I always tell my clients to have at least a primary attorney in fact and a secondary attorney in fact. If the first attorney in fact, the primary attorney in fact can't act, you want someone else who can then take up the slack. So oftentimes it's a couple who will come in to see me. For the primary attorney in fact, they will each be each other's attorney in fact, which is great, because the thing to know about a power of attorney, and this again is in New York and New Jersey, I believe this is the general principle, but it may be different in your state. This would be something to look into. Once a power of attorney is signed, it's operational, which means whoever that primary attorney in fact is, they can act on your behalf. You don't need to be incapacitated for a power of attorney to operate. So the problem this creates is, if someone nominates an unscrupulous attorney in fact, they can act like you. So if you own a house, they could sell that house. If they had access to certain financial accounts, they could get access. They could wipe out those financial accounts. So you have to be careful who you're nominating. You have to make sure it's someone you trust. It should go without saying, because they're dealing with primarily your money, and you want to make sure that you trust them. But it doesn't happen that way sometimes. It doesn't happen that way far too often. There are people who are always looking for a negative angle, and they prey on certain people who are subject to that. So make sure that when you're nominating someone, make sure you really trust that person, because that power of attorney will operate immediately. You could make what we call a springing power of attorney. That's a power of attorney which will not operate unless there's a finding that you are physically or mentally incapacitated so that you can't carry out your financial or administrative or governmental functions. The downside to a springing power of attorney is the same downside as a guardianship. It's essentially the same. We have to get two doctors normally to go examine you, to say that you're incapacitated physically or mentally. They have to write a report. There has to be an attorney hired who would then file an action in court to state that you're incapacitated, so that the springing power of attorney should now spring into power and the attorney in fact can operate on your behalf. Guardian ad litem would be appointed. They would go visit you. They would visit everyone else. There's a fair amount of expense, and there's a fair amount of time delay in that. That may run counter to your whole desire in having a power of attorney, but if you feel most comfortable with that, then you should most certainly do that. But I just want to let you know the downside of a springing power of attorney. It in many ways thwarts the whole purpose of a power of attorney. But if you have any reservations at all, or if you just want to make sure, it's not that I have reservations about my attorneys, in fact, I just want to make sure that I'm the only one, as long as I'm capable, I'm the only one who deals with everything. Then that's fine. Then that's what you would do, as a springing power of attorney. One other issue is if it's a couple with minor children. If we imagine a situation where if we're getting to the secondary power of attorney, in fact, what we're dealing with, that would mean that both people in the couple are incapacitated. So someone would be taking care of the minor children. So there's something to think about there. A lot of times people think to themselves, well, I'll separate who's ever taking care of my children from who's ever taking care of the money. Two things about that. First is that could create some delay in, if there are matters which have to be taken care of for your children, there could be some delay there, because the person taking care of your children has to go to this other party to get money to take care of your children. You don't have that delay, so just think about what that delay would cause for the person taking care of your children. Now, it could be that the person taking care of your children just feels like it would be enough for me to take care of the children. I don't want to deal with the money. That's fine. I will note, though, in my experience, when there's a separation between who's taking care of the children and who's taking care of the money, for some reason, that raises the idea that the person taking care of the children can't be trusted with money. And it sometimes creates a lot of friction there. So just, if you're going to go that route, be clear with the people involved why you're doing it. If it is that you don't trust the person around money, you make whatever decision you want, but do you really trust them with your children then? But if it's simply a matter of, we don't want to overwhelm the person dealing with our children, we want to make sure that they're there for that mentally, that they're fully present, make sure that the person in charge of the money knows that. Make sure that they know that there's not a trust issue there. Because that kind of friction can create a problem, which, when I say a problem, I always mean attorneys get involved and money gets spent on attorneys. That's what we're trying to avoid here. The next issue is, if you have this power of attorney that you have, it won't generally operate with your financial institutions. Each bank or financial institution that you have accounts with will have their own power of attorney form. And that's because they don't want the bank teller or the customer service rep or the broker to have to look at your document, your independent third-party document, and determine if it's a legal document. So what they do is they have their own document generally. So for any bank account you have, any institution you're dealing with, inquire with that institution about their power of attorney. It will be separate from your power of attorney, but this will make sure that if something happens to you, that the people taking care of you can then access your bank accounts appropriately. It makes life much easier. Technically, do banks and financial institutions have to honor the power of attorney which an attorney drafts? Technically, they do. However, in New York, every time they don't, it's a $25 fine. There's not much incentive for them to take an action, because what they'll say is, just go to court and get me an order. Or you could have simply used our power of attorney. So it cuts down on delay, it cuts down on aggravation, and it just makes everyone's life easier. So even if you get a power of attorney from an attorney, go to your various financial institutions, get their power of attorney, and file that power of attorney with the bank or the financial institution, so that if something happens to you, there's someone to take some backup action. Another way that people deal with that is they make joint accounts with children. Joint accounts are not a great idea, because you're giving the other person, once an account is joint, you're giving someone else ownership. That's what it means. So if I have a bank account and I make it joint with someone else, that doesn't just mean that person has administrative powers. It means it's their money. That's not good. So if you were to do a power of attorney with the bank, you could limit, for instance, they can't make gifts to themselves. They can only use the money for these various functions. You can attempt to work with the bank to put parameters on what would happen. So the two final issues that are not state specific. The first is, should your agent get paid? The attorney, in fact, should they get paid? That's completely up to you. Generally, in my clients, they don't have the attorney, in fact, get paid. But if you were going to use someone like an accountant or some other kind of a professional, they may insist that they get paid in order to take on that type of a function. It could be they might be viewing themselves more as a bookkeeper in that matter. People have asked me to be their attorney. In fact, again, I wouldn't do it. I only do it for clients I'm really close with, because I just don't like the appearance that I'm trying to get the client and talk my way in to be their attorney. In fact, it just doesn't feel right to me. But I've had certain clients which I am very close with, and I will do it, but I need to get paid for that, because I can't take away from my practice in order to not get paid. But if it's a family member, generally people don't pay family members to be their attorney, in fact. Final issue that's not state specific: should the attorneys, in fact, if there are multiples, should they have to act together, or can they act separately? The benefit of them acting together is it's another level of security. Everybody knows what's going on then. Everybody knows, every attorney, in fact, knows that a certain transaction is being undertaken. No attorney, in fact, can act rogue. The problem is that it could create a scheduling issue. So let's say you have 2 or 3 children, and they're all going to be your attorneys in fact. If you require that they all act together, that means every document that's going to get signed, they all have to sign. Every transaction which is going to take place, they all have to be present. It could create a scheduling problem which could push things back. If someone's going to act as your attorney, in fact, they have a fiduciary obligation to keep themselves involved. So they can't simply say, oh, I'm your attorney in fact, and so is my brother. I'm just going to let him do everything, and I'm not going to deal with anything. I'm just going to kind of fall asleep at the wheel. They have a duty to stay involved. So in that duty, they should be following up with the other person. They should be having regular discussions, what has to be done, what's being done. There should be enough of a safeguard there. But if you feel they both have to act together, you can insert that in your power of attorney. This last section is just for New York State, because New York State has its own statutory power of attorney form. They have a power of attorney form and a gifting form. Briefly on the gifting form, that became necessary because people were appointing as their attorney, in fact, certain unscrupulous people who were making gifts to themselves. So the example would be an elderly person would have a newfound friend, make them their attorney, in fact, and suddenly everything disappears out of the person's bank account, their house gets sold, and the attorney, in fact, is gone. So the point of the statutory gifting power is you can state in that document, it's a separate document because we want people to know this is extremely important. This person can take action on your behalf. Within those actions, they can make gifts to themselves. Do you want that to happen? So if there are multiple children, the way to deal with that is to say, nobody can make a gift to themselves, but the children can make gifts to each other. And the reason why you would want that is if you had to do some sort of government benefit planning where you have to get yourself down to a certain asset level, you need to do gifting generally. So child A gifts to child B gifts to child A. Final issue is for the statutory short form. So if someone is thinking, well, I'm just going to go online, I'm going to get a form in New York. The government made a form, I'm going to go with that. In Section F, which is where all of the powers are laid out, Power N states all other matters. Most people, reasonable people, would read that and say, that means that every possible power is included in this power of attorney. But you're wrong. The New York State Court of Appeals has ruled that certain matters are so important that they can't be covered under the all other matters power. This is a trap for the unwary. If you're not an attorney, even most attorneys don't know this if they don't practice in this area enough. For my power of attorney form in New York State, I've added 17 other specific powers based upon certain matters, certain court cases where the court has said this power needs to be specifically delineated. So for instance, on the power of attorney, it states the attorney in fact shall have power to conduct real estate transactions. The Court of Appeals said, great, they can sell the property, but they can't sell what's on the property. So now we have to add real estate transactions, including all fixtures and articles of personalty therein, which just means, yeah, you can sell the house, but this also gives you the power to sell the furniture. Insurance transactions, that's on the main power of attorney, including borrowing from, transferring ownership, or surrendering the policies. So what the court said initially was insurance transactions merely means paying the premium. But there's a lot of other things which can happen with life insurance. So it's issues like that which don't just get a form in New York State online. Or if you do, it's fine if you just get a form. But understand, if one of these 17 other areas comes up, there will not be the provision that you can avoid guardianship. The whole purpose of the power of attorney is to avoid guardianship. So you can have a power of attorney in New York with the all other matters covered. But if one of these 17 other areas isn't included, and this list may grow, you may still have to go to court so that the person, even though they have your power of attorney, they can specifically be given these additional powers by the court. So don't fall for the trap of all other matters. But if you are in a hurry, just understand if one of these other areas may come up, and they generally deal with being more specific about the powers on the power of attorney, or dealing with certain matters with inheritances, whether it's not just accepting an inheritance, that's covered, but if you want to say, I don't want an inheritance, which you may want to say to maintain government benefits. Also, certain matters dealing with the IRS we're dealing with Medicaid or Social Security, certain specified matters aren't covered under the main power of attorney. So we need to include these other matters. It's generally dealing with government benefits. So just know that that problem may exist. I'm not saying if you really feel like you just want to go out and get the New York short form and fill it out today, you still have to get it witnessed and notarized. That's fine. But just know it doesn't actually cover everything that you may want to cover in your power of attorney. I hope that you found this helpful. If you did, please hit like and subscribe. That's very helpful to just make sure. The reason why we do that is the more people like and subscribe, the more people will be notified this may be a video which is of interest to you. Like I said, if you have any questions, feel free to post them below or contact me. I really appreciate you taking the time. This is now a little over 20 minutes. I really appreciate you taking the time to watch this. Like I said, there'll be 2 other videos, one about healthcare proxies and living wills, and one about wills. I hope you have a great day, and please stay healthy.